Hi, we are going to get started. I'm Liz Deckman. I'm a partner in the Benefits and Comp Group at Dorsey and Whitney in the Seattle office. I'm very happy to be here and to welcome you to the third annual Forum on Employer-Sponsored Benefits, which I think is great. I see some faces that are coming back and back again, and some new faces, and so thank you for coming. We have a jam-packed schedule today, so I'm going to turn it over to our first panel with Melinda and Andrew and Kirsten. I'll let them introduce themselves, and they're going to be talking about litigation and employee benefit plans.
Well, thank you, Liz. This is Melinda Maher, and I'm a partner here at Dorsey in the Minneapolis office in the Benefits and Compensation Department. And I want to echo Liz in welcoming you to our third annual Employer-Sponsored Benefits Forum. And I want to thank Liz because this was really her idea a couple years ago, and she continues to push us to do that. So thank you, Liz. And thank you to all of you in the room and on the phone. We have a big crowd. And we're going to talk to you today about litigation in the health plan arena. And although I am in the Benefits and Compensation Department, way back in the distant past, I started my career here at Dorsey in the trial department. And I am so grateful now not to be doing litigation and to be able to turn it over to our fantastic litigators that we have, two of whom we have on the panel. The younger, nimbler people here are the litigators, and they're fantastic. So I'm going to turn it over to them to tell you a little bit about themselves. Kirsten, Schubert, and Andrew Holly. Kirsten, can you?
Good morning. I'm Kirsten Schubert. I'm a partner in our trial group here. I do a lot of ERISA litigation as part of my more commercial litigation practice. I do a lot in the health plan space, but I also do quite a bit in the retirement plan space too.
And I'm Andrew Holly, also a partner in the trial group where I focus most of my practice on ERISA litigation, both health and pension. And we're excited to talk to you about the health plan litigation.
So we would love to take your questions as we move along, and then we will allow time for questions at the end as well, hopefully. So feel free to chime in at any time. The first slide that we're showing you is what we intend to cover. And in the litigation arena, plans usually face two primary adversaries, two categories of primary adversaries, either providers or participants or wannabe participants. And what we're starting with is the providers, because that's really where we're seeing a lot of activity in the litigation arena. As Andrew has educated me, in particular, there are things called these mass actions, which he's going to talk about. So we're going to talk a little bit about what the providers are doing, what they do ahead of litigation, and then how you can respond. And then when you're in litigation, what's happening and how you can respond in some ways that plans can push back against the providers. And from there, we're going to move into more specifics on the types of cases we've seen in the last year, in 2018 and the end of 2017. Those are kind of the more traditional participant claims, and we're going to talk about some of the specifics around those. And then finally, we'll end with what are the regulators doing. If you look at the slide I have here, I should have put HIPAA privacy under what the regulators are doing, because as many of you probably know, in the HIPAA privacy realm, there is no such thing as a private cause of action. It has to be brought by the regulators. But in fact, they are very active in that arena right now. So we'll talk a little bit about that. So moving on to our aggressive providers. And for those of you who might be providers in the room, this is just our characterization. You may not think of yourselves that way. But I'm going to ask Andrew to talk to you a little bit about what we're seeing from providers, particularly on fee forgiving and other things. Andrew?
Yep, thank you. So one of the things we've seen in the last few years is we've seen medical providers get more and more aggressive about their claims against insurers and against health plans and against TPAs. A very common thing we're seeing is that a medical provider will obviously we've all been to medical providers, and when you go there, you sign those assignments away, giving your rights to claims and things like this to the medical providers, both to file claims for benefits, but usually also, if you read the fine print, it's like you're giving them the right to sue in your name as an assignment of a claim. And what we're seeing more and more is these medical providers are taking, 100,000 or 100 or 1,000 of these claims, and they're suing either the health plans themselves or the TPAs that administer the health plans or the insurers. And essentially, so if you think about the claim, the medical provider will literally have 1,000 patients that they will provide a procedure for, whatever it may be, and they'll go after the health plan. And so what you'll literally have is you'll have an action that's really a class action, because you really have 1,000 patients at issue here. But because the medical provider has assignments from them, they can bring it on their own, in their own name. And so what you have is you have a situation where you have a class action that doesn't have to be certified, but it has all the complexities of a class action, because you literally have thousands of claims, thousands of different patients, thousands of different medical, thousands of, reams of medical records and such things. But and so they're very, very difficult to manage. They're very complicated, and just the data management is extremely complicated. And these are happening more and more and more and more. And in fact, not only they're not just being brought against the the TPAs or the administrators anymore, but sometimes they're suing, dozens, maybe even dozens, even hundreds of group health plans themselves. The plaintiff's attorneys, frankly, the plaintiff's attorneys do it off sometimes because it's just to put pressure on the health plans to make sure the health plans know what's going on behind the scenes. It's when to put pressure on them to try to settle the claims, because they feel like it's easier to do that. It's easier to, frankly, get a settlement if you have to pressure the health plans themselves. One common area that's found here, and one common area this is found here is when the health plans refuse to pay for claims because there's fee forgiving. It's a common thing in out-of-network areas where network providers, where the out-of-network providers say, look, we're going to come to us, we're not going to charge you any deductibles, we're not going to charge you any co-pays or anything like this. And from the health plan standpoint, and from the TPA standpoint, this is a very, very dangerous thing, because the whole point, obviously, as I'm sure you all know, of having out-of-network, having larger charges for out-of-network is you want to kind of guide people in-network. You want them to go to the cheaper in-network providers where you've negotiated discounts, rather than the out-of-network providers where there's essentially, they can charge whatever they want. And sometimes you'll see some healthcare providers refuse to charge deductibles, and the health plans and the TPAs will say, well, no, we're not going to pay for this at all. And so you're seeing battles about those sorts of things, where the providers will sue and they'll raise claims saying you should have paid us, and then the health plans or the TPAs will raise counterclaims saying, no, you deserve no payment at all because you've waived fees, fees and coverage. So that's just one example of the kind of fights that are out there, and you can expect healthcare providers to become increasingly aggressive to the extent that these are successful. Yes, question.
How are those claims coming out, and does it depend on the plan language?
When they say how they're the question was, how are the claims coming out, and does it depend on the plan language? And when you say how are they coming out, can you?
Are the providers winning?
Sometimes. There's a Cigna case where the Cigna had a good deal of success, although I think that was now on remand. They've had some success now, but there's a lot of settlements out there as well. And the plan language is incredibly important in these claims, because as always with ERISA, it's very, very technical questions. And for example, to give a couple of examples, the one issue that's huge in all of these is anti-assignment clauses, and we're going to be talking about that. And if your plan doesn't have an anti-assignment clause, it's something you need to think about very, very, very carefully, because obviously, as I said, the whole way that these claims come up is that the medical providers get assignments from their patients. And if the plan has language saying you can't assign your right to receive benefits or fiduciary claims, then that's a huge defense. Now, it's not automatic because there's waiver issues and all this kind of stuff, but it's a huge defense. And just to give you, I'll give you, I could talk for longer than anyone you would want to hear about the intricacies of these kinds of things in the plan language, but just to give you one example of the kind of thing that matters. A lot of people have anti-assignment clauses in their plans. And a common anti-assignment clause will say something like, you cannot assign your right to receive benefits to anybody else. Sounds good, right? Well, so the problem is that the medical providers will raise breach of fiduciary duty claims under ERISA. And they'll say that, oh, you breach your fiduciary duty because you've improperly managed these claims, or you improperly failed to give us our benefits. And, there's arguments of whether or not that's a viable claim or really should be a claim for benefits. But on the anti-assignment clause, suddenly you've got an anti-assignment clause that you thought was great and was fantastic, but it doesn't preclude people from assigning their right to raise breach of fiduciary duty claims. And so suddenly you thought you were gold, but suddenly you have a breach of fiduciary duty claim against you, and then you're fighting it out in litigation. That's just one example of the kind of intricacies and plans that come up in these litigations, and something that it's really important to be staying on the cutting edge of these things if you want to stay out of these sometimes nuisance but sometimes not nuisance pieces of litigation. Does that answer your question?
And not to get ahead of ourselves, but on the fee forgiving, we've actually talked about ways to craft plan language to try to defeat that practice. It was my thought that we would already have that language in effect, because if you think about what we say, what we're going to pay out of network, we're going to pay a certain percentage of something, usually, usual and customary or something. And if they're forgiving the cost sharing, my argument would be, well, that drops what you're actually billing, but it starts to get real complicated real fast. And I've talked to Andrew about this. So what we've taken to doing is sometimes trying to put language in the plan that says if you're going to forgive cost sharing, then we're not paying. Now that can get tricky too, because there are legitimate times when providers forgive cost sharing. We all know those times. And if somebody legitimately cannot pay, we don't want to stand in the way of those people getting care. So that's the line you walk. It can get difficult on that score. I'm going to tackle the aggressive letters requesting documents under ERISA and making threats. So I have, let's see if I can get to the, oops, sorry. So here's an example of a letter we've gotten, and we've gotten many of these, I would say, through clients. I think this particular one is maybe 12 pages of what I call screed of you are violating ERISA, my God. And then they have this list of documents they want from you. And it can be very scary when you get this. And I think they deliberately target sending it to the employers rather than to the TPAs, because they know employers will, get a little exercised about it. So we have some strategies for dealing with that, which we'll tackle on the next slide. But Kirsten's going to talk about also what we see from, in particular, I hate to single out any provider, but dialysis providers are very aggressive because they are providing so much care. What Andrew and I have seen is they're very active in making sure that the commercial plans are primary to Medicare in that space. And Kirsten, you've had some experience with them as well, right?
Right. So like Melinda said, we're having quite a bit of litigation come up with specifically related to dialysis providers. As I'm sure many of you know, there are a couple of providers in the space that take up a really large percent of the market share. I've heard numbers that DaVita and Fresenius together take up, at places around the country, 70% of the market space. And as you can imagine, this gives them a lot of leverage to increase their prices at an exponential amount, very close in time, so year over year. Just a couple of statistics for you. We're seeing one case where the rates that DaVita is charging just over the past year are 1,354% higher than the usual and customary rate for that area. It's 800% higher than the national per treatment charges for those services. And get this, 2,737% higher than the Medicare authorized reimbursement rates.
Hence the reason they don't want Medicare to be primary.
Right. And these services are really vital to these patients. A lot of times they come at end of life. Patients need a lot of care. They need a lot of treatments on an ongoing and regular basis. So this has a really big impact on both the patients and the plans who are paying for these exponential rate increases. So what we've been seeing in the non-Medicare space, I'll say, is that claims administrators have been denying out-of-network services on a blanket basis, and then we're also seeing some plans that have the dialysis providers, for example, DaVita, as an in-network provider, and so in some cases the TPAs are actually getting an auditor in and looking at a usual and customary rate for each claim and using the auditor basically to justify the usual and customary rate. For instance, I've seen a couple of plans actually where the services are excluded unless they fall within the usual and customary rate. So that particular TPA was able to say, all right, this is what we're going to pay on a service by service basis. And now DaVita is coming after the TPA, looking for payment that is more in line with their billed charges. In addition to bringing claims against the TPA, in this particular case, we see the providers actually going after the plans. So through the TPA action, they're seeking payment from the plans, through the TPA, bringing that. And then they're also parallel seeking payment from the plans themselves. So we're fighting it on two fronts in some instances. And it's a really aggressive measure. We're seeing just these really aggressive litigation tactics. And in some instances, it's probably a kind of mechanism to settle. In some instances, I think it's preservation of claims due to statute of limitations issues. But don't think that you are not subject to litigation directly just because you've got a TPA who's administering these claims.
Yeah, that's.
And just another point on this. One of the, not only do they have, so there's a bunch of reasons why the dialysis providers are being aggressive right now. Not only do they charge a ton of money because these are ongoing services, because they're end-of-life services, they're expensive. They have incredible market power, but also the Medicare rules have specific rules for end-stage renal disease. And these rules for end-stage renal disease, among other things, if you violate the rules for end-stage renal disease, they will at least arguably provide for double damages and attorney's fees. And so you put those things together, and these are very, very powerful and difficult claims to deal with. And just to give one example of something that's happened here, I have one client who had one of the major dialysis providers come after them, and they said that they had a plan exclusion for end-stage renal disease, not that didn't exclude benefits, but that said that they had those benefits had to be paid at a certain rate, at a usual and customary rate. And this was an attempt. It was a good faith attempt to try to control these charges, right? It was a good faith attempt to say, look, these people you're charging a lot of money. We want to be able to at least say that the charges for these services should be at a usual and customary rate, very normal. Right? Well, the dialysis provider said, look, this is the only services that you've identified that are subject to this usual and customary rate in this plan are end-stage renal disease rules. And because of that, the Medicare rules, the ESRD rules in Medicare say you cannot discriminate in rates of payments based on ESRD. You can't do it. And that's, that is what they say. And so suddenly we're in a situation where a good faith attempt to kind of control these charges has been identified as discriminatory. And they said, you can't pick and choose here. You can't do this under those rules. And as a result, the client was facing a potential double damages and attorney's fees if they didn't resolve this matter. And so the point is that not only are they being aggressive, but again, it's one more time, as we'll say over and over again here today, is that the technicalities of the plan. This is something that they could have done in another way. They could have found a way to structure this plan to achieve this result in the same way. But just because they were, again, this is all arguments at this point. But they face some risk here simply because they and their TPA were unaware of how those rules worked.
Thank you. We'll skip over this letter and talk about kind of how to respond to those threatening provider letters. So I think the first piece of advice that Andrew has given me is, don't accept what they say at face value. And that is certainly true. When we look at the letters, typically they are throwing the kitchen sink into them, and they aren't necessarily correct. So that's the first piece of advice. So you're going to want to call somebody if you get a letter like that who can help you, not an advertisement necessarily for us, but somebody you should talk to. The other success that I've had is working in tandem with your third-party administrator or your carrier for that, because what I typically see, I have actually even seen, so what's really going on is the providers are kicking their, their stale, their accounts receivable over to collections, and these are really ultimately collections who are coming back with these threatening letters. So I actually have even seen these letters coming from in-network providers, which to me is a little shocking. And what I've told my clients is you need to go back and talk to your TPA or your carrier. That's ridiculous that you should be getting this from an in-network provider, for one thing. And normally that's helpful. But also, I think the TPAs are on the front lines and have seen this. They typically will know the provider, and they can also partner with you in responding. So that's another piece of advice I would have. And I don't know, Andrew, if you have any other thoughts on those letters.
Yeah, I think the most important thing is to realize that they're incredibly overbroad and very dramatic, and they're trying to threaten you with DOL sanctions and prohibited transactions, and of course they're in all caps to make it seem threatening. But the reality is there's almost always they're almost always inappropriate, and they're almost always too far. That doesn't mean you can't ignore them, right? Because they may be requesting some documents that they're entitled to. But just for example, they're usually requesting historical documents, and if it's an ERISA 104B request, that's not appropriate. Or they'll say that there's penalties if you don't give them documents related to this particular claim. Well, you don't have penalties for that side of things to get sort of into the minutia of ERISA. The point overall is that they're almost always inappropriate, but it is a good time to try to check in with your TPA to see what's going on. I mean, there's usually some sort of issue there that's not totally illegitimate, or at least there's some claim that has been denied. And it's oftentimes a good time to check into what's going on with your TPA to understand if is the TPA refusing to pay claims because of fraud? Is there a concern about a particular service? What's going on here? So it's an opportunity to understand what's going on with your health plan, and that's generally speaking, I think it's a good idea to try to figure out what's going on in your with the administration of your health plan, because there's a lot of money sloshing around, and and it's nice to know.
Yeah, completely agree. Kirsten, you.
Yeah, I mean, for example, in the dialysis litigation I've been talking about, a lot of the health plans and the employer sponsors have no idea that the claims are being administered in this way. It's just not something that's on their radar. So clients are surprised when they find out that these usual and customary rates are being applied when the billed charges are 2,000% higher than that rate. So it's just another example of why it's important to talk to your TPA and just keep in the know about what's going on.
Yeah, good advice. So another tactic are these anti-assignment clauses in the plans, and I have become convinced by these two of the importance of getting those particular provisions in the plan, and not only having an anti-assignment clause, but making sure it is, as Andrew described, pretty thorough. And I've actually seen there's really good case law now out there, and Andrew, correct me, and Kirsten if I'm wrong, but even within the last, I would say, year, confirming the ability of plans to say that you cannot assign particular things, which can really help to defeat these claims, and particularly I would think on these mass actions. Am I correct in saying that the case law is favorable on that? I would say
it is. Yeah, it is. I mean, there's always going to be some ups and downs, and the people that always argue waiver by that you've waived it by doing this or doing that. But generally speaking, courts will recognize that anti-assignment clauses are valid and effective, and the same goes for forum selection clauses. At least in sort of large ERISA fiduciary matters, courts will enforce forum selection clauses, and they may have some problem with a $10,000 benefit claim or something like this that's filed in Hawaii and you want to move it to Minnesota. They might not care for that so much, but in large fiduciary class actions or large fiduciary cases, they will enforce those, and you can have that decided in a jurisdiction that and you understand where your lawyers are. Yes.
I'm sorry, this is all really new to me, but are you saying that, so this anti-assignment clause piece, who is ultimately responsible then if the patient is signing or waiving rights, and then the employer or plan provider and the back money, who's paying in the end?
So the question was, who's paying in the end if you have an anti-assignment clause and if there's a lot? And so to answer your question, and to get a little technical about it, I mean, the plan is still paying, right? And it's still paying on behalf of the patient. It's just that any lawsuit that would have to be brought by the patient themselves, right? So the only effect of an anti-assignment clause, and apologies if we weren't clear about it, is it just says that the patient has to be the one the patient has to own the claim, the patient has to be the one to bring the lawsuit, the patient has to be the one to prosecute the claim. That means that a medical provider can't do it on their behalf. And really what it is, to be frank, it's a procedural thing that stops the medical providers from essentially aggregating 100 or 1,000 claims. And it's, it makes sense because, frankly, those are very, very difficult claims to deal with. They're complicated, and it's very, very hard to deal with the data. And how are you supposed to determine whether 1,000 surgeries were medically necessary, each one with their own rights or their own issues? It just basically says that the health plan is still responsible for paying the claims. They pay it on behalf of the patient, and if there's a lawsuit that has to be brought, it's brought by the patient. Now, and just so to be clear, the DOL requires that hospitals and medical providers be allowed to submit claims during the ERISA claim for benefit process. They have to be allowed to have what's called authorized representatives. So your health plan cannot preclude that from happening. So, but it's at a different step when you're actually talking about litigation. Nothing requires the plan to allow their participants to assign their rights to hospitals or medical providers to sue. Does that answer your question?
Yes, and if the providers do bring these mass claims that we were talking about before, how, as an employer, we're like lumped in that mass piece of it, and we have to deal with that?
Yes, the question was if the hospitals do provide those, do bring that lawsuit against the employers, are you wrapped into it? And the answer is yes. You could, the hospitals will sometimes sue 50 to 100, 200 individual employers and their individual health plans. And, sometimes you can get lawyers to represent groups of people. That certainly happens. But you will have to address it one way or another on your own, or face, the potential of a default judgment.
Sometimes the TPAs will go ahead and defend those, is that?
Yeah,
is that
the
correct?
TPAs may arrange for the defense. It doesn't mean that the TPAs may arrange for the defense. We've certainly done that, and we've certainly represented, over 100. There's one matter where we represent over 100 plans in that matter. So it's not like you're going to be on your own. It's just, but it is something you're going to have to address one way or the other. There's a question back there.
Have you had any success on dispositive motion practice where there was not an exhaustion of remedies? So under the plan, there's, the denial or the DOB pays something, but not 100% of what the provider is saying is due and owed. And then the patient just kind of, it doesn't take it to the next level, doesn't escalate it on appeal. Have you had any success on, I don't know, motion to dismiss or motion for summary judgment where there's no exhaustion of remedies and then the TPA is coming in after the fact?
Yeah, and the question was, have we had success on, in dispositive motions and litigation where the claimant has failed to properly exhaust their ERISA remedies? And the answer is yes. That is a very, very important defense, and one that's often raised. We've won multiple cases where the patient has simply failed to exhaust their claims.
The
And so-
patient or the provider? The provider didn't
Yes,
take
the
it up.
patient or the provider. And that raises an interesting question. If the provider does a poor job of representing the patient during the administrative phase of that, right? They don't file their appeals and all this kind of thing. I mean, what does that mean? Because in theory, the patient is still responsible for the bill if the provider doesn't do a good job with that. But that's a question for another day. But the answer is yes. That's a very important defense. And sometimes, or even if it's been too, that raises another issue about the plan, because sometimes if the claim has been filed, if the claim hasn't been filed within the time frame, you can not only argue that the case should be dismissed because it should be exhausted, but you can say that they can't exhaust anymore because the time frame for doing so has ended. So that's a very, very important defense, yes.
So are these types of claims covered under the EPNL, or is there a different type of coverage that an employer should be looking at now?
I'm sorry, what are you referring to, though?
The employer practices liability benefit coverage, is there a different type of coverage that we need to cover us for these kinds of things, or?
That's a very good question. The question the question had to do with the kind of coverage the kind of insurance cover that you need for these kinds of claims, and what's the policy and what you need to have for something like that. And generally speaking, is it going to generally be covered by, I think it's like the general employment coverage, insurance coverage that you're going to have. And the first answer is, to the extent that we're talking about benefits here, you're not going to get any coverage for that, because no employer is going to, unless you have just a straight up insurance policy, no insurer is going to give you just a policy that's going to cover your failure to pay benefits. In any policy, there's going to be what's called a benefits due exclusion, which is going to say that, look, if as a practical matter, what you're being forced to pay is benefits that were due under the terms of the plan, then we're not going to cover it, unless it's just an insurance policy, it just makes sense. However, on the breach of fiduciary duty side, you're almost always, there's obviously you have to look at each individual policy, but you're almost always going to have a fiduciary policy, which is going to be separate and apart from anything that you're going to likely get from just an employer side policy. And this is, frankly, it's even more important in the pension side of things, to be frank, because that's where the fiduciary claims are much more serious. Here, in the health space, the fiduciary claims are usually just kind of ancillary or window dressing to the benefit claim. But yeah, you absolutely will have to have almost certainly will have to have a fiduciary policy that will specifically cover breach of fiduciary duty claims under ERISA. And there's multiple instances in which you can have a situation where benefits aren't due in a situation for whatever reason, but that you're going to be found guilty the court might find that you're guilty for breach of fiduciary duty because for example, you didn't process a claim correctly, or you didn't give the employee proper advice about how to maximize their benefits or things like this. So those kinds of claims are all over, and there's some recent Supreme Court case law that has made it much easier to raise those kinds of claims. So if you don't have a fiduciary policy for your health and your pension plans, it's something you should absolutely think about.
Yeah.
Question. So what is causing this to be more prevalent now? You have your plan design, claims are denied, that's always happened. What's happening that it sounds like all of a sudden there's...
That's a really good question. The question was, why are these claims more prevalent now? Why are these out-of-network claims more prevalent now? What's going on in the world that's making it more prevalent? And there's no one thing. I think that to a certain extent, I think that that's just changes in the healthcare industry. I think that some of it's a reflection of the fact that the TPAs are getting better about identifying issues and potential issues out there. I think that's one of the issues. I think that there has been some recent Supreme Court case law that's made it a little easier to sue for breach of fiduciary duty, for example. But I think, frankly, the answer really is that people just kind of figured it out. The out-of-network ones, I mean, there are some in-network ones, but those are usually more contract claims. First of all, those are more contract claims rather than ERISA claims. And second of all, obviously there's an ongoing relationship there, and I think that those things are oftentimes worked out more. The problem with the out-of-network providers, of course, is they have no contract with anyone, and they can charge whatever they want, and the TPAs are doing their best and the health plans are doing their best to say, no, you have to charge something that makes sense and is reasonable. And the out-of-network providers are like, well, no, it's like, you can't just tell us what we're going to do. We don't have a relationship with you. The plan terms govern here. So I don't know the actual answer to your question, other than just to say I think that in litigation, and particularly in ERISA litigation, which is pretty esoteric, people are getting more and more sophisticated every day, and they're learning more and more about it. And I think people are just figuring things out. Question? So the question was, are we seeing more issues having to do with, are we seeing litigation having to do with indemnification claims between the TPAs and the health plans? And Kirsten can talk about this too. She's dealing with this a little bit. But what I would say is that it's always an issue. It's usually an issue that's worked out. In terms of formal litigation, of course it happens, but normally I would say that it's always an issue you have to be thinking about. It's an issue, you're certainly, everybody needs to be thinking about the indemnification provisions of your agreement with your TPA, but it's an issue in a lot of cases, and it's something but at the same time, it's normally the parties can work it out, or they can be reasonable about it. So, Kirsten?
Right, I mean, that's generally, I think, the industry experience. One thing to look out for is, if you get notice at the beginning of a suit against a TPA and then, don't do anything about it, you stick it in your file and, the issue turns over between benefits people, or people just sort of move on with their work lives. The issue can come back a couple years later, so there's nothing preventing the TPA then from coming back and saying, hey, we've been litigating this for 3 years, we went on appeal, we've been in district court, now it's coming time to, get together a settlement or move to trial, and we're gonna let you know we're coming back to you for the amount of fees that we think you owe. And, in that case, it can take plans and employer sponsors by surprise. And I think that's the thing to look out for. Again, I think it's a work with your TPA and keep in good communication, but just generally keep in mind that you could be on the hook for their attorney's fees, which is something to consider.
Yeah,
Go ahead.
I think that's such an excellent point. And the one thing I would say too is I'm on the front end normally not litigating over the indemnification clause, but trying to negotiate the indemnification clause in your service agreements. And I would say there's like 2 or 3 provisions that I focus on in those agreements, and that is obviously one of them. That is a huge provision to look at. And the one thing I have seen is this trend among vendors to cap liability. So they'll cap straight up liability, and they may or may not cap indemnification liability. So that's something really to pay attention to in your contracts. And sometimes the caps are very low, which if I'm negotiating on the part of the employer is typically unacceptable. If I'm on the vendor side, it's okay.
So I know, just to kind of go through the rest of the slide here, the next 2 bullet points are both talking about the kind of the same thing, and that's just making sure that your plan terms are up to date. And I cannot, ERISA is so document specific, unlike contract claims where courts will usually find some, kind of do what makes sense, equitable doctrines, et cetera, et cetera. ERISA is always so plan specific and so document specific. And if there's one piece of advice that as a litigator I could give to you, that would be sort of how do you prepare for the next piece of litigation that you don't know is coming. It's make sure that your plan documents are in order. Simply because, the reality is you get your plan documents, they look great, they've got everything going, but 3 years down the road, your practices change a little bit. You have a new TPA maybe, or maybe the people who were, the plan administrator who was supposed to be deciding claims changes, or, as a practical matter, the day-to-day world, we're always doing different things. Or maybe you get a new insurance policy, or you have a new SPD, or whatever it is. It's very, very common for us to get into a situation with litigation, and, the client will give us the plan documents, and, we'll almost always see something that's where time has moved on a little bit. And, in the real world, this is the way the real world works, but the problem is in litigation, particularly if you have a sympathetic plaintiff, the courts will kind of latch on to those kinds of document errors and say, oh, because of this little thing here, we can't grant summary judgment to you. We don't have a motion to dismiss, and we'll have to go through the discovery phase and all the kind of burdens and difficulties of that. So if there's just the one thing you really, really, really want to do in preparation for litigation is just making sure, to give another example, what is the plan document? Oftentimes you've got 4 or 5 pieces of paper that are your plan document, and sometimes they're internally inconsistent, and sometimes they'll say, a document will say, hey, this is the plan document. Another one will say, this is the plan document. And it's very, very difficult to kind of mash that out on an early dispositive motion before a court, where the court's like, well, I don't know what any of this stuff means, and it can result in a lot of litigation, a lot of heartburn and discovery and things like this. So it's really, really helpful to kind of make sure that your plan documents are in order, that as somebody in the benefits group used to say, that you're doing what you're saying what you're doing.
Yeah, and I'll just echo that. The one thing I see so frequently is you get your document from your vendor and you use it, and it normally will say, but the plan document controls. And there is no plan document. And so Andrew hates that, that he's constantly carping at me about that. So try to avoid that if nothing else. So we'll move on to when you get Andrew to help you if you get sued. And Kirsten, what do they do to counterclaim, I guess, is what we're talking about here.
Yep. And so just as we've seen the medical providers become more aggressive on these areas, we've also seen the health plans either on their own or through their TPAs become more aggressive as well. I remember reading an article, I think it was in the Wall Street Journal, referring to an open war between the healthcare out-of-network providers and health plans. And one of the things that we're starting to see now more and more is we're starting to see health plans, again, either on their own or represented by their TPAs, start to file recoupment actions against medical providers who've overbilled, overcharged, in some instances engaged in outright fraud. Again, because this is ERISA and because nothing's ever easy under ERISA, the how you do that is extremely complicated, extremely complicated. To get a little technical here, ERISA has kind of a narrow set of remedy provisions. And the remedy, there's the only one that would really allow this is what's called 502A3, which allows you to obtain equitable relief. Well, if you pay a bunch of money to a medical provider that you shouldn't have, and you just want your money back, that's not equitable relief. So what you have to do under your plan, and this is just an example to show you the complexity of it, and once again to harp on how important it is that your plan documents are up to date and reflect the most recent sort of thinking. You have to have language in your plan that allows you to put an equitable lien over money that was overpaid to healthcare providers. And then what you're going to do is you're going to enforce that equitable lien under 502A3. And I'm not kidding about this. Literally, you're looking at 19th century case law explaining what an equitable lien is and how that's different from a cause of action in the courts of chancery versus the courts of law. And that's literally the Supreme Court cases are talking about those distinctions, and it's just mind-numbing. But that's what ERISA provides for. And the point of it is that these recoupment claims are very helpful and very powerful, and they're very necessary for the health plans, but it also is something that's very technical and very complex. And you have to have the right plan language, or you can find yourself in trouble. And just we talked before about how we have the mass actions by the providers. One of the issues you have if you wanted to bring a recoupment claim is that you're oftentimes acting on behalf of maybe 50 to 100 health plans, each one with their own terms, each one with their own provisions. And so if you want to plead these claims, you want to bring these claims, you have to do so in a way that you have to manage the data and manage the plans in a way that makes sense too. Because you have to present to the court, say, hey, these plans all have this particular exclusion for where there's copay waivers, or all these plans have the required language that allows you to put a constructive trust over the assets that were inappropriately delivered. So again, it shows the difficulties of pleading that stuff and putting that into a complaint and kind of managing all that data they're significant.
Do you want to say anything about the antitrust lawsuits?
Yeah, we'll also, in addition to sort of the ERISA claims, there's also state law claims too for fraud, for conversion, and these kinds of things. And the trick there, obviously, is that they're dealing with ERISA's preemption provisions, and that you have to be able to walk that line where you're raising ERISA claims under the plan for recoupment and these sorts of things, but also the sort of fraud, that also state law claims for fraud and conversion and things like this. And we've done it successfully, but it's a kind of you're walking on a tightrope. And just also one of the things that we've seen, that I've personally seen quite a bit, is health plans pay a lot of the healthcare market, healthcare delivery market is in some instances, not so much here, but in some areas it's a very concentrated market. And we just talked about Fresenius and DaVita, who have very significant market shares, and in some instances you'll see parties with very significant market shares engage in antitrust violations, which will significantly increase the costs to health plans. I'm personally representing a couple of health plans who have potential antitrust claims against a hospital system in Northern California, which the hospital system has been sued in various class actions, and including by the AG. And I'm representing a group of health plans that are simply raising their own claims, not in litigation yet, but raising their own claims against the health system to try to recover under the antitrust laws. And the antitrust laws are very plaintiff friendly. They allow for treble damages. They allow for attorney's fees. The point is that there's a lot of opportunity. There's a lot of money that goes through health plans and are paid out to health care providers. And I think what you're seeing is not only the providers being more cautious and more aggressive about trying to get paid, but the health plans are getting paying more attention to what's going on. They're starting to realize, and they have real significant, powerful claims that they can raise against and to recover some money for both the employer and for their participants.
And just to give an example of the kind of claims that might be brought under a fraud theory is, this copay waiver instance where, we have providers waiving the member responsibility amounts. So, you go in, you're supposed to pay a copay or a coinsurance fee, and the provider says to you, oh, we'll go ahead and take care of that. Don't worry about it. We'll just charge you whatever your insurance wants to pay. Just let us deal with that. And so the TPA on behalf of the plans or the plans themselves are coming back and saying, well, no, that's fraudulent. You're representing to us that you're taking care of the claim and collecting the member responsibility amounts when you submit your claims, but you're not, in which case you're kind of inducing the patients to take services when otherwise they wouldn't be permitted under the plan. The other kind of sort of fraudulent action that we're seeing in that space is, we actually have providers who are lying to patients about what kind of services they need, and in a fraudulent inducement in trying to get them to take on services in order to, bill the plan for those unnecessary services and potentially, induce the patient to take on even more services. So we'll see a provider saying, oh, you need this kind of surgery down the line. So we think that you need to get, some kind of endoscopy done, some kind of nutrition counseling, some kind of mental health treatment. So we're going to provide you all those services, package it up, not charge you anything, and then we'll charge your provider or your healthcare plan at the end for all of that together. And so that's actually one fact pattern that we're seeing providers take on that the plans are really striking back on.
Great, thank you. So we're going to move on from the providers. We'll talk about some of the participant lawsuits that we've seen. The first one was a class. There are actually 2 class actions against Cigna, and really the allegation is that basically Cigna is passing on what is administrative cost, kind of passing them on as a claim cost, so that to the plan and to the participants, it looks like it's a claim for benefits, but it's really an admin cost. And what I thought was interesting, so the participants are saying, look, we're paying too much because the cost sharing is too high. You're adding in these admin fees to the claims cost. So that's still in litigation and hasn't been decided. But what I thought was somewhat interesting about this was not only is the allegation that you're overcharging, essentially, you, Cigna, the TPA and the insurer is overcharging, but also that they're doing it in order to manipulate the minimum loss ratio. Some of you may be familiar with, under the Affordable Care Act, now they have these requirements they have to meet in terms of what is claims cost and what is admin cost. And so the allegation is not only are you incented to manipulate what is a claim cost because it makes you more money, but also because it helps you with your minimum loss ratio calculation. So that's still making its way through the courts, and we'll see how that ends up. We also have seen a trend in litigation regarding pharmacy benefit pharmacy benefit managers that we have only called PBMs, and I apologize, I'm just inside baseball. But Andrew and Kirsten, I think you guys can talk a little bit about the PBM litigation that you've seen.
Yeah, so there's a number of claims that are raised against the pharmacy benefit managers, and the issue there is always, the area is very, very complex, and it's very easy for the plaintiff. The funding of these things is very complicated, and the money flow is very complicated, and it's very, very easy for the plaintiffs under ERISA to start calling things plan assets under ERISA or saying that this is a privated transaction. And that's exactly what they're doing, not surprisingly. They come up in a number of different circumstances, and the problem ultimately with these claims is that they're so complicated that it's pretty easy for a court to get confused about, confusing between, the administration of a plan and the administration of a business. And it's very easy for plaintiffs to identify things as a plan asset and say privated transactions and use these words, and the judges just sometimes will throw their hands up, not always, we've had success, but sometimes will just kind of throw their hands up and say, this is complicated, we have to go into discovery. So.
Okay, moving on from there. So also a breach of fiduciary duty claim that we have seen recently out of the Eastern District of Arkansas. I think, Kirsten, were you going to talk about this case?
Yeah. So this case is for IV Metropolitan Life Insurance, MetLife. And this I thought was a really interesting case just because it's a little bit different. Here the court found that there was no claim for benefits. Essentially what happened was there was a participant in a life insurance plan who had insured her dependent under the plan when he was 23 and under 23. And that was consistent with the provisions of the plan terms. And when she was signing up for this policy, you know, she goes to the website that's sponsored by her employer, American Greetings, and, you know, she puts in a very small amount of information, basically like her dependent's name, I think, and then herself. And there wasn't, you know, like a birth date requirement. There wasn't any kind of other status or eligibility information taken on the front end. So over the course of a number of years, she simply rolls over her enrollment so that she's continuing to get the coverage, and then she's also continuing to pay premiums on the life insurance policy. And then her son dies, he's 24, and so she goes to the life insurance company to collect the benefit. And the life insurance company denies her claim, saying, well, you know, he had to be under 23 in order to collect on this claim, and, you know, he was 24, so you're out of luck. And the court found that that decision was consistent with the plan terms, and so there was no viable claim for benefits under the plan. But the court looked at this from a real fairness perspective under the breach of fiduciary duty claim and found that there was a breach. The court looked at the practical reality of her enrollment process and said, you know, life insurance company, MetLife, and American Greetings, you know, MetLife was responsible for administering the plan. American Greetings was responsible for collecting the information. They found that they didn't work together closely enough to collect the right information at the right time and then administer the plan. And as such, it was a breach of their responsibility to administer the claim with care, skill, and prudence. And, you know, the court actually suggests in its opinion that the company should have used like a text box at the beginning or like a pop-up window in order to collect that information. And so it was really a scheme of information collecting. And so the court entered judgment against the claim provider, the claim administrator, and the provider, the sponsor, and issued a judgment and then issued a surcharge for the amount that the claim would have been worth had the claim paid out. And, you know, the other interesting thing that the court noted was that the American Greetings actually had the information about his birth date in their records because they had collected the birth date information for the medical benefits side. So I think had that information not been available to the employer, it would have possibly gone the other way. But the court found, you know, you've got the information, it would have been really easy to utilize it, get your act together.
The court is obviously not particularly aware of some of the privacy issues in the medical field, I guess, but there's a question back there?
I mean, I think their position was there's nothing specific that requires us to do this. It's the same essentially as if somebody gets divorced, right? You have to notify the plan or the sponsor or the claims administrator, hey, I got divorced. This is no longer a dependent of mine. They should no longer be insured. Their position was that when the participant aged out, the mom should have notified the insurance company. There was no obligation for the insurance company to continue to monitor that. And, the other thing the court was really concerned about was that the insurance company was collecting premiums on this person over the course of time. And in this case, because the person was deceased, there was a claim that came in and the insurance company could refund the premiums. But had the person not passed and had there not been a claim, then the insurance company would have collected the premiums. And the court was very concerned about the fact that, the insurance company is basically benefiting from the premiums.
And this case is the one that I was kind of referring to earlier, and it's emblematic of a lot of cases out there. A couple of years ago, there was a change in Supreme Court law that allowed kind of expanded damages for breach of fiduciary duty that affect a person rather than the plan. And because and this is something that comes up all the time, where there's I haven't read the records of the pleadings in this case, but I imagine that the employer's defense was, look, if you read the stuff, you know that the person wasn't eligible for it, and you should have done this. It's not our job we can't possibly be telling everybody about every particular circumstance or situation that might affect them. You have a responsibility to understand what's going on. Because of two things, because you're a fiduciary for these purposes, and when you're dealing with your employees, when you're and with connection with health plan plan situations, the courts will oftentimes find that there's not just a duty to not just a contractual duty to comply, to do what you say you're going to do in your contracts and things like this, but in fact, there's a duty to go to be above and beyond and make sure, to a certain extent, make sure that your employees understand their benefits, that they're understanding what's going on, that they understand their health care, they understand the best way for them to apply for long-term disability or for health or whatever it is. And courts will say that, if your employees are confused, you have sometimes, in some instances at least, courts will say you have an obligation to help them out and help them to figure it out. And it's a very, very common situation where some individual employee will have done something that makes them not eligible for benefits under the terms of the plan. But they'll argue that the employer, either made a mistake or wasn't forthcoming enough about what I needed to do to be eligible for benefits under the terms of the plan. And because you're a fiduciary, your failure to do so is a breach of fiduciary duty. And if that's successful, notice what that does. Suddenly you go from a situation where you thought you had a plan benefit that was insured by somebody, you thought you were assured, you thought your Cignas of the world were responsible for this, we're supposed to cover it. Well, suddenly the Cignas of the world are saying, sorry, you didn't comply with the terms of the plan, and that's just too bad. And the employees are saying, well, maybe that's true, but I think that the employer screwed up, and I think that the employer now owes me money. So it goes from an insured benefit to your payment obligation.
Right, which is always my worst fear when I'm representing the employers, so it's something really to pay attention to. We have to move pretty quickly through these last slides. The next case that we address in the slides is an ERISA interference claim, and what I'll say about that is I always worry about this. This always is a threat in the termination of employment context. If you're terminating an employee, certainly don't talk about how much the employee's son is costing the health plan. That's a bad idea. And that was, I think, part of the bad facts that happened here. Mental health parity, I want to talk about, this actually is becoming a bigger and bigger deal, and I think the next session will touch on this as well. But we have definitely seen an uptick in litigation activity under mental health parity. It is a very complex law. And what I worry about for my client employers is they very much have to defer to the TPA on the ground or the carrier to comply, but ultimately liability can flow up to the employer. So I'll say that, and I don't know if we want to say too much else about it.
Yeah, I'll just say very quickly that a couple of years ago, the DOL came out with these non-quantitative treatment limitations, which nobody really understands and are very, very hard to implement. You'll hear about them in the next session, but this is something that you should just be concerned about, and you'll hear more about it next session.
Yeah,
I guess we'll leave it at that.
Sorry. Oh, in two sessions, not the next, I'm sorry.
Okay.
So leaves is next, and then you'll hear about it. So you got to stick around. You got to. Okay, the HIPAA privacy claims. So this really goes into the category of regulatory action. OCR hit Fresenius with a $3.5 million penalty, which is bad, but as we've just talked about, Fresenius makes a ton of money. So to them, that may not be the biggest deal. I think the bigger deal is the corrective action plan for at least 2 years that they're subject to. So, and this was triggered really what looks to be carelessness on the part of a variety of different provider practices owned by Fresenius. And they, basically had things lost or stolen out of cars, for example. So this, I think, is a call to pay attention to HIPAA. And if you didn't need that call, here's another action that might give you pause, which is actually a criminal action. You can be subject to criminal penalties under HIPAA. And this is an example where they're bringing such against a provider who, in my mind, looks like she was just trying to do the right thing by her patient, but is now being prosecuted for it. Also mention that we have more stringent disability claims regulations, so you want to be paying attention to that. And the one nuance there is it's not just with respect to disability plans, but any sort of benefit you might have that's based on a disability finding. So for example, life insurance plans, if there's a disability waiver, these new regulations may be triggered. And finally, we end with retiree medical, where everyone wants to end. in their life, but can't. And actually, the Supreme Court has had 2 recent cases which are making it even harder for, making it easier for employers to terminate their retiree medical, making it harder for participants to argue that they're entitled to retiree medical. I don't know, Andrew, if you have anything else to say about that, or Kirsten?
That's a perfect summary, yeah.
Okay. So with that, I think we will wrap it up, unless there are any quick questions? Nope? Okay, I guess that's it.
Great. Well, thank you very
Thank you.
much, you guys. We will take a 5-minute break.